You are now joining the meeting.
Afternoon, we'll get started here momentarily.
Okay.
One moment, okay?
Okay, thank you.
Thanks. While I'm getting this ready to go on the record, who's with me? Is that Ms. Hadley?
Kimberly Hadley, yes, sir.
Mr. Quintero?
Audio conferencing center. Please enter a conference ID, followed by pound.
Hello?
Hi, Mr. Quintero, are you there?
I am David Quintero in propria persona, present by special appearance.
Okay, well, we're not on the record yet, sir, but thank you for identifying yourself.
If you're the meeting organizer, press star now.
Okay, can everybody hear me?
We can, yes.
Yes, yes. All right, excellent. Thank you, folks. We're on the record. This is in SP 2017-0042. It's in the state of Arizona through the Department of Economic Security and David Quintero petitioners and Kimberly Hadley respondent. This is a date and time set for order to appear reinforcement of child support. And let's have the record reflect that both parents are present, and David Ronald, Assistant Attorney General, is present on behalf of the state. Let me have both Mr. Quintero and Ms. Hadley raise your right hands. We'll have you both sworn in. Thank you.
Do you and each of you solemnly swear that you will speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I'm not here for that matter. I'm actually waiting for a response for the documents I filed on the record.
Okay, Mr. Quintero, you haven't answered the question, though. Are you swearing to God or affirming that you'll tell the truth in these proceedings? Did you hear the vote that was just administered, sir?
I appreciate your questions, but I'm only here so that we could either dismiss the matter with prejudice or you could write an order I can appeal. I am here in propria persona by special appearance.
Okay. Excellent. Thank you, sir. Let's just have the record reflect that Mr. Quintero has not so sworn or affirmed, and so he is therefore not considered to be under oath. The court will therefore consider that and developing its inferences in connection with any statements that he makes in connection with the proceedings today. Sir, just for your information, and frankly for the information of the parties generally, the court has ruled, the ruling was issued today, so it's in the court file. Sir, generally speaking, the one action that you filed that the court allowed and is considering in connection with today's proceedings was your motion to dismiss for lack of subject matter jurisdiction, which motion was denied. So you'll see the court's ruling. It's been filed, sir. Okay? So, and the court has addressed in that ruling all filings by Mr. Quintero. So the only matter that's pending today is the request to enforce support, and so we'll be going forward on that matter today, okay?
I do not agree. I do not consent. I am only here so we can motion to dismiss for lack of jurisdiction with prejudice, or you can write your order so I can appeal.
The order is written, sir. I want you to understand that it's been written and it's filed, okay?
I do not understand. I'm not interested. I do not consent.
Fair enough. Thank you, sir. Okay. We'll proceed despite Mr. Quintero's lack of cooperation with the proceedings. And let me just ask, Mr. Ronald, do you have any questions for either Mr. Quintero or Ms. Hadley at this time?
Judge, this is actually the petition was filed by a mother in this case. So I can start Judge, with some questions for Mr. Quintero.
Do you have any preliminary matters that you want the court to consider at this time?
Judge, there was in this case, state's information that the last payment was made December 6, 2020, which was by unemployment, which has been coming in at $120 a week. And there's only been the one order in this case, which was issued July 31st, 2017.
Do you have an approximate number? Do you have an approximate amount of arrears?
Yes, Judge. Our amount, based on a calc report done November 2nd, 2020, is it's a principal amount of $8,876.60 and an interest amount of $1,845.63. And it's from the period of August 1st, 2017 through October 31st, 2020. I'm not sure that the mother has the exact same figures that the state has come up with in its calc report. So.
Got it. All right. So the approximate arrearages are principal and interest combined about $10,000. Is that what I heard? Is that right? All right. And when was the last time that Mr. Quintero made a voluntary payment?
I'm just looking at that, Judge.
He's never made a voluntary payment. I'm sorry.
Ma'am, I'm sorry. Just please don't interrupt. I only want one person to speak at a time. Thank you.
Of course.
Just checking real quick, Judge. So, Judge, it does appear that the first, there was a payment from an income withholding order. I'm not sure if the judge, if you're considering that voluntary or not, but there were, back in June of 2020, that's when the first income withholding order payment came in. And prior to that, there was a payment in May of 2020, a tax seizure. So other than that, there's been unemployment. There's 3 income withholding order payments and then unemployment. So, but it's all been since May of 2020. So, and the original order was in 2017. So.
All right. Thank you. Before I hear from either parent, do you have any questions? I know you're not the petitioning party, but would you like to ask any questions of Mr. Quintero?
Oh, the state judge?
Yes.
Yes, I have a couple.
Okay, you may proceed.
Mr. Quintero, can you hear me okay?
I'm not interested in your question. I'm not interested in your question. I do not consent.
Then, Mr. Ronald, he can hear you. Just go ahead and ask your question. It'll be up to Mr. Quintero whether or not he's going to respond. Mr. Quintero, I'm directing you to respond, and I'm also just advising you that by not responding, the court will consider a negative inference in connection with any non-responses, okay? All right. Mr. Ronald, go ahead.
Thank you, Judge. Mr. Quintero, we have that your reported earnings for 2018 were $6,585.42. Do you agree with that?
I don't know who you are. I'm not interested. I appreciate your questions, but I'm just here so this matter could be dismissed with prejudice, or you can write an order I can appeal.
And just for the record, it's David Ronald, Assistant Attorney General. And sir, Mr. Quintero, you would agree you made no payments for child support in 2018?
Again, I appreciate your question, but I'm not interested. I do not consent. I'm just here so this matter could be dismissed with prejudice, or you can write an order I can appeal.
And then, Mr. Quintero, it looks like we have reported earnings for 2019 of $13,782. Is that correct?
Again, I appreciate your questions, but I'm not interested, and I do not consent.
And Mr. Quintero, isn't it true that you did not make any child support payments in 2019?
I appreciate your questions, but I'm not interested, and I do not consent.
And isn't it true in 2020 that you are receiving unemployment payments? Is that correct?
Sir, I don't know what's going on. I'm not interested, and I do not consent.
Thank you. No further questions, Judge.
All right, thanks, Mr. Ronald. Ms. Hadley, do you have anything that you wanted to add at this time, or do you have any questions for Mr.
Yeah, sure. I'd like to add a couple things. I have emailed Exhibit A and Exhibit C that I'd like put on the record. Exhibit A is I downloaded the payment record from the DCSS website, which
our clerk's shaking his head that he doesn't have any exhibits. Did you provide those to the clerk of the court?
I emailed them as instructed in the notice to jruberg@scpima.gov.
One second, I'll see if I have them on an email, but have you disclosed those to Mr. Quintero and
I emailed them all the attorney general. Yes, sir, I did.
Okay. One second, ma'am. So, first of all, do you have any questions for Mr. Quintero?
Do I?
Yes or no?
No, I don't.
Okay.
I don't ask him questions, sir.
And let me just make sure, Mr. Ronald, you don't have any other questions for Mr. Quintero?
No, Judge, and I would just note for the record, the state did file the arrears calculation. Looks like November 6, 2020.
All right, thank you. Do you have any questions at all for Ms. Hadley?
Yes, Judge.
Okay, go ahead.
Ms. Hadley, you had indicated that you were seeking enforcement in this matter because Mr. Quintero has not been making consistent payments, correct?
When I originally ordered this, and I called your office to make sure too, Mr. Quintero had made it clear to the DCSS case manager that I had spoken with. He made it clear to me, and he had not at the time. This was originally filed with other concerns I had of his behavior in March, and he had made at that time no voluntary payments at all. And to this date, he has made no voluntary payments and has made it clear that he has no intention of ever making any payments in this case. All of the things that have been brought in to the COVID and they've been seized.
Sadly, just listen to the question. I'm gonna give both you and Mr. Quintero an opportunity to be heard further, okay? But I'd just like you to answer the questions right now that Mr. Ronald's trying to ask you, okay?
Sure.
You've heard the state was questioning Mr. Quintero about different years where he's earned some income. Do you know anything about his job history?
He won't disclose anything to me, so no, I don't know. I just know he wasn't paying.
And then there was the state prepared an arrears calculation based on the payments and the amounts owed. Did you review that?
I did get it, yeah.
Okay. Do you agree with the numbers that were in that report that the state provided a copy to all the parties?
I mean, it does appear to be in lines with what's on your website as well, I would assume. So.
Okay. So you don't disagree with the amount?
I don't dispute. No, I don't dispute that. Yes, sir, I don't.
Okay. No further questions. Thank you.
So, Ms. Hadley, was there anything that you wanted to add at this time? Go ahead, ma'am.
Yes, Your Honor, I want to add a few things. This case originally was not established as what is it called, an or whatever it wasn't established to.
4D. 4D.
Okay, the 4D, it wasn't established in that manner, and Mr. Quintero had adequate years of disputing and litigating it. I previously had a lawyer who, Mr. Quintero, had tried to get this dismissed several times. I'm sure every party's aware. And it's been denied several times based on that as he brought this whole matter, he is the petitioner, he's not the respondent. He brought this whole matter to the court system for them to decide on these matters. And he's just not in agreement with what the courts have decided. So I first want to say that originally this did not originate as a 4D case. And he did pay when it wasn't a 4D case, and he had no intentions of paying after it was. It's just that the DCSS has been able to intercept the money that the government has given out for the COVID pandemic, and those are the payments that they've been intercepting now. But he's never voluntarily paid anything on his child support order.
Thank you, ma'am.
Sure.
And Mr. Quintero, is there anything else that you want to say on your own behalf?
I am present by special appearance in propria persona. I do not understand what's going on, and I'm not interested. I do not consent, and you can dismiss this matter with prejudice or write your order so I can appeal.
And sir, did you know that you had a child support obligation back in 2017?
I appreciate your question, but I'm only here so you could dismiss this matter with prejudice, or you could write an order so I can appeal.
Are you aware, though, that you had a child support obligation that was entered where you were the obligor in that case, in that order?
Again, I appreciate your question. I'm just not interested, and I do not consent. You can write your order to dismiss, or an order I can appeal. Make sure it has a seal with a wet ink pen.
Is there anything else that you want to say to the court?
You have no jurisdiction over me. I do not consent. You have to prove jurisdiction on the record. And you can either dismiss this matter with prejudice or write an order I can appeal.
All right, thank you, sir. Mr. Ronald, was there not a child support order entered on July 31st, 2017?
Judge, in this case, there was an order entered, and the order was entered on July 31st, 2017, with an order that would be effective August 1st, 2017, of $317 a month.
I'm sorry, what?
Mr. Quintero, didn't you file a motion for reconsider? I'm stating it the way you've written it. Motion for reconsider or decision overturned. It was filed August 4th, 2017.
You know what? I appreciate your question. I appreciate your question, but I'm only here so you could just dismiss this matter with prejudice or write an order I can appeal.
Do you dispute that you signed said pleading August 4th, 2017?
I'm not interested in the question. I do not consent.
Understood. Thank you. Let me just ask any of the parties, beginning with Mr. Ronald. Mr. Ronald, do you have any other questions, or are you familiar with the exhibits A and C that were submitted to you and Mr. Quintero?
That's by Ms. Hadley.
Yes.
Judge, when were those sent over to the state? What date?
I don't know. Ms. Hadley, can you clarify? First of all, the clerk doesn't have those exhibits. So I'm not inclined to admit any exhibits that haven't been provided to the clerk. There's a drop box, I believe, on the. I'll get some clarification from our assigned clerk, Frank. Is there a drop box? Second floor. So any exhibits have to be submitted to the clerk of the court. They have an area on the second floor of the Superior Court building where those can be provided, okay, so that legal records can receive them and have them prepared for purposes of the proceedings. That hasn't happened today, okay?
Okay, Your Honor. I was just following the notice orders, like what it told me to do in there. So that's fine.
Okay.
It's not crucial.
All right. So with that, is there anything else that any party would like to present in the way of any evidence? Mr. Ronald?
Judge, just to avow to the court that Mr. Quintero, his reported earnings for 2018 for the year was $6,585.42. For 2019, $13,782. And for 2020, $7,074.08. And just that the first, there wasn't a payment made in this case till 2020. So the order was in 2017.
Thank you. Ms. Hadley, do you have anything additional?
No, I mean I don't have anything additional without the exhibit. So no, because Mr. Quintero worked for cash. He's an entrepreneur.
Mr. Quintero, do you have anything additional at this time?
I am present by special appearance in proprio persona. I do not understand what's going on. I just need an order so I can appeal, or you can just dismiss this matter with prejudice. That's all I'm here for.
Thank you. That wasn't additional, but thank you. Mr. Ronald, do you have any recommendations?
Yes, Judge. The state would recommend that Mr. Quintero be found in contempt, and that a judgment be ordered based on the arrears calculation dated November 2nd, 2020, that was filed in this case, with the principal and interest amount that those be ordered as a judgment.
All right, thank you. Ms. Hadley, do you disagree with any of those recommendations?
No, sir, I don't disagree with anything. I just
Any disagreements with those recommendations?
I don't know what's going on here. I don't understand. You don't have jurisdiction over me. Jurisdiction was not proven, and I have no interest in this matter. You can dismiss this with prejudice or write your order so I can appeal.
All right, thank you, sir. The court does find that it has continuing jurisdiction in this matter, both with respect to the subject matter as well as the parties involved. The court does further find that there is a current child support obligation. It's a valid order. The court further finds, and the court does take judicial notice of the file, and specifically the motion for reconsider or decision to overturn filed August 4th, 2017 by David Quintero in connection with that child support order. The court finds that Mr. Quintero does in fact have notice of said child support order, and specifically that's the order that was entered July 31st, 2017. The court does find that Mr. Quintero is non-compliant with said child support order. The court finds that Mr. Quintero has never made a voluntary payment in connection with that child support order, and despite having sufficient income to at least make good faith payments in both 2018 and 2019, that he failed to make any child support payments. The court does find that he's currently unemployed. He's receiving unemployment insurance benefits, and some of those benefits are being applied to his support obligation. The court does find that his non-compliance was willful. The court does find him in contempt of court for failure to pay child support as court ordered. The court, as a purge, the court just orders that Mr. Quintero report to the Division of Child Support Services any employment that he obtains between now and the review hearing that the court will be setting. And let me just ask you, Mr. Quintero, I suspect you're not going to answer the question because of the way you've responded to all other questions, but presumably in order to receive those benefits, are you in the process of looking for work?
I appreciate your question, sir. I'm just here so you can either dismiss this matter with prejudice, write an order, I can appeal. You have no jurisdiction over me. Let's all just write an order with a sink and a wet ink pen so I can appeal. I have no interest in any of these questions. For the record, I do not understand what's going on. I have no idea what's going on here, and I do not consent.
Okay, I'm going to order. Thank you, sir. So the purge is as follows, and this is so that Mr. Quintero can purge his contempt that's been found today in connection with these proceedings. To any employment that he should obtain between now and the review hearing within 2 weeks of obtaining new employment, that he report that to the Division of Child Support Services. The court will further order that Mr. Quintero apply for a minimum of 3 jobs per week beginning this week between now and the review hearing. The court will further order that Mr. Quintero report to one of 2 agencies, either Arizona at Work or Pima County One Stop. In order to obtain services in connection with his desire to find a job at this time, his need to find a job at this time. So let me just ask you, and I suspect that there will be a similar response as you've already stated as to all questions that have been asked today. But do you have any source of income other than your unemployment insurance benefits?
I appreciate your question. Just here so you could dismiss this matter with prejudice or write an order I can appeal. Thank you.
Thank you, sir. And let me just ask Mr. Ronald, anything else that you're asking the court to consider as the purge of his contempt?
No, Judge, I think the court covered it.
All right. And I'm going to set a review hearing, so if everybody will please look at your calendar, I'll set a review hearing in this matter.
Judge, is it going to be a signed minute entry with the principal and interest amount as a judgment, or how is the court going to do that?
I'd ask that the state submit a form of judgment.
Okay.
And then the court will review it and consider its findings and orders today. And if it's consistent with the court's findings and orders, it'll go ahead and sign that, and it'll be filed. All right. I'm looking at the date of March 31st. It's a Wednesday. How about 11 a.m. that day for 30 minutes?
Okay.
Sounds good, Judge.
Mr. Quintero? Mr. Quintero, did you hear the date and time for the review hearing?
Is that a question?
Yes.
Oh, I appreciate your question, but I'm only here so you can either dismiss this matter with prejudice or write an order I can appeal.
Okay, this order setting the matter for review hearing, March 31st. This coming year, 2021. That's at 11 a.m. cause may result in the court making a finding of contempt for failure to appear, and a child support arrest warrant may issue. The court does not find today that Mr. Quintero has the ability to pay any more than what is currently being withheld from his unemployment insurance benefits, and the purge is, again, that he report any employment that he obtains between now and the review hearing within 2 weeks of obtaining that employment to the Division of Child Support Services case manager, that he apply for a minimum of 3 jobs per week between now and the review hearing. That's beginning on today's date, and that he report to either Arizona at Work or the Pima County One Stop to obtain any additional guidance or services in connection with his job search. The court's already set the review hearing. Again, the date and time of the review hearing is March 31st, 2021 at 11 a.m. And call-in information will be provided between now and the review hearing. I don't think there's anything else that we can do in this matter today. Ms. Hadley, do you have anything additional, ma'am?
No, thank you.
All right. Mr. Quintero, anything additional? And you don't have to repeat what you've already said. Do you have anything additional, yes or no?
You have no jurisdiction over me. I have witnesses that witnessed jurisdiction not being established. I order this matter dismissed with prejudice.
Okay. That request, I'll consider that as a oral motion for reconsideration of the court's ruling already with respect to Mr. Quintero's motion to dismiss for lack of subject matter jurisdiction. The court ruled today. Earlier, that ruling is in writing. It was filed on today's date. The court's construing his statement as a motion for reconsideration of said ruling. The court denies his motion for reconsideration. And let me hear from Mr. Ronald. Mr. Ronald, anything additional?
Judge, so in the order that the state prepares, I'm going to leave the payment on arrears at blank at this time. We'll put 0, or what would the court prefer?
Well, yes, I'm not entering a payment on arrears today. I don't know that there's been one entered. If the existing child support order, which as I've already found is a valid order, entered as I already stated, and I don't see a payment on arrears included. So, and the court's further not entering a judgment on arrears. So the court reserves entering any judgment on arrears at this time. The court reserves entering a payment on arrears.
Judge, there may be an administrative one that I'm seeing of 10461.
And administratively, that could occur. And
okay.
I know Mr. Quintero's not going to give the court enough information for the court to consider a payment on arrears. Based on my findings today, I'm not inclined to enter a payment on arrears. But of course, whatever the state, as a matter of law, will be doing administratively may adversely affect Mr. Quintero, but that's something that he can take up on administrative review if he believes that the state has incorrectly utilized its administrative remedies. So that's something Mr. Quintero can address administratively if necessary, and that's something that's going to be reserved at this time. There's nothing else that the court's going to find. Thank you. There's nothing else that the court is going to do to address the pending matter today. Any additional matters will be addressed at the time of the review hearing. That's on March 31st of this coming year at 11 a.m. That's for 30 minutes before the court. And we're adjourned, folks. feel free to hang up at this time. Thank you.
Thank you.
Thank you.
You never got it. Never got it.